Hi, I'm Christopher Burgon. I own and run Christopher Burgon Solicitors. We are a specialist litigation and commercial law firm based in London. So the question that everybody asks me when they're thinking about instructing a solicitor is, how much is it going to cost? What a question. It's probably the question on everybody's mind, and I'm going to try and give you the answer in this video. And of course, I'm going to warn you, the answer is, it depends. What we're going to try and do is give you some estimates, give you some idea of how much the kind of work that we do, which is solving direct-to-shareholder disputes and other commercial disputes, actually costs. I'm going to give you 6 figures: £300,000, £120,000, £30,000, £8,000, £2,400, and nothing, 0. What is the significance of those numbers? I'm going to tell you now. £300,000. £300,000 is a very broad estimate of how much a commercial dispute, if it lasted for a 4 or 5 day trial, would cost if you took it all the way to trial to get a judgment from the court. £300,000. Is it going to be worth it? Well, it is worth it if your business is worth a couple of million. And to get control of your business will cost you £300,000 in fees. Don't forget also that in England you can recover your costs from the other side. There are entire libraries written about how much of those costs you can recover, but the general principle is that the loser will pay the winner's costs, and you will recover at least a proportion, and if the case has been properly run, a high proportion of your costs. So there you go, £300,000. That's the figure to scare you off. I'm never going to do that, you're going to say. And of course, I'm going to say that's for a reasonable commercial case worth a couple of £1 million, a 4 or 5 day trial. You can recover your costs. Here's the other thing, is that very, very few cases or disputes go to trial. Very few disputes actually end up in court. Of those that do go to court, very few actually end up in trial. So I'm obliged by the SRA to tell you about a final figure if the case went all the way. So this is me telling you about the final figure, £300,000. Now that your breathing has regulated a bit and your heart is back to a normal kind of rhythm, we'll carry on. Let's go to £120,000. Let me tell you how I get to that £120,000 figure. I'll give you some background about how court cases run. If you've got a really unreasonable opponent, somebody who will not settle without court proceedings being issued, then you're going to have to bite the bullet, you're going to have to issue proceedings. Now, the first stages of court proceedings involve you filing a document if you're the claimant, which is a claim form with particulars of claim. They then have a chance to file a defence. There are various other similar documents, all of which are called statements of case, such as replies and counterclaims. Once you've been through that process of exchanging your statements of case, then the case will go on to an administrative phase. Now, it will be listed for something called a Costs and Case Management Conference, a CCMC. At the CCMC, the court will set a timetable to take the case through to trial, and it will also set a budget for you to do that work. It'll look at all the costs to date, and it'll set a budget for the rest of the case. Now, it's at that point, could be because people see at that point how much case is likely to cost, and because they probably have a better idea about their chances of success, that people start to negotiate in earnest. So previously, completely intractable litigants who really were going to hang on tight so that they could get a result and try and browbeat you into capitulation. If you take them to a CCMC and then say go for a mediation or just a simple negotiation after a CCMC, my experience is that is when you are most likely to be able to settle a case after proceedings have been issued. £120,000 is my estimate of costs to get to that point. So that's all the stuff, all the negotiations before going to court, exchanging the statements of case at court, preparing and attending the CCMC, and the costs of a mediation or negotiation after a CCMC to reach a settlement. £120,000, that is my rough estimate. Again, of course, that depends on the complexity of the case, the size of the case, but that's my rough estimate of costs. The third figure, £30,000, already 10% of the trial fee, so already 10% of the cost of the trial. What do I think costs £30,000? I think if you've got a dispute with a fellow director shareholder and it's a pretty complex action, not too complex, not too much involved, relatively complex, and there's some real bad blood between you and your fellow director, and they really dig in, they really want to cause you problems, then to get to a settlement without issuing court proceedings, I think will cost you £30,000. Last year, a dispute between a brother and a sister, the brother just would not compromise, kept writing us letters telling us how wrong we were about everything, which was sheer nonsense. Still, we managed to come to a deal where we bought his shares out, and the costs of that were £30,000. Next figure, £8,000. You come to me, you go, we've got a dispute, can you help us out? We look at the issues are not too complex, we get in touch with the other side can see the sense in coming to a settlement rather than fighting it out, so everything is pretty simple, runs pretty smoothly, then it's going to cost you around about £8,000, I think. Now all of these figures are plus VAT, I must say, but bear in mind we started off with £300,000 for a 5-day trial of a serious commercial case. We're now down to £8,000 to settle a director and shareholder dispute in an SME matter. Fifth figure, £2,400. That's what we're going to ask for from our clients as a payment on account. We'd love to speak to you. If you say, okay, we'd like to instruct you as a firm, that makes us really happy. We say, great, show to us that you're serious, give us a kind of deposit for our fees. That's £2,400. The final figure was £0. Nothing, it's for free. As you say, we love to speak to business owners in trouble, we love to help them out. We particularly want to help the honest business owners who are trying to create wealth, help them defeat the people who are trying to undermine them and rip them off. And to speak to us is absolutely free, it costs £0. When we speak to you, we'll give you an initial assessment of your case. We'll also give you the best information we can about costs, but at the beginning, it's going to be pretty general. This is a pretty general estimate of costs in this video, but as we go along the case, we'll give you updated information about costs all the way through. So there you go. I hope that was helpful. If you have a matter that you would like to discuss with us, a director shareholder dispute or another commercial dispute, then please get in touch. Getting in touch is easy. Please go to the website, press the book a meeting button. That allows you to pick a space in my diary at a time and day that suits you. It's absolutely free of charge. That's the final figure is £0. Alternatively, drop us an email, give us a call, and we'll get back in touch, or leave a comment or leave a question in the space underneath this video. Thanks very much.